Welcome to the Pennsylvania Case Law Update While You Drive podcast. You give us less than 20 minutes per week, we will make sure you never miss changes in the law. This week's episode is brought to you by the McShane Firm. For nearly 20 years, the attorneys of the McShane Firm have been trusted by our neighbors and our friends to represent them in DUI and criminal law cases.
Thank you for joining us for episode 31 of the Pennsylvania Case Law Update While You Drive podcast. I'm your host, Katie McShane, and today we are covering cases decided between January 20th and January 26, 2021. We will start this week with a timeliness question in a PennDOT license suspension appeal. In the matter of PennDOT versus Middaugh, the Supreme Court discusses whether or not PennDOT can suspend a driver's license for DUI when the court fails to report the conviction to PennDOT in a timely manner. In this particular case, the defendant was convicted of DUI and at the time was expecting the suspension of his driver's license. He had made accommodations. His car had been totaled and he did not purchase a new one. He was employed and would have been able to rely on his wife to take him places if necessary. The court delayed in reporting the conviction for 28 months. In that time period, the defendant had purchased a new vehicle, he had lost his job due to a neurological disorder and was divorced and could no longer rely on his wife. Under the law, PennDOT must suspend a driver's license when a conviction resulting in suspension is reported, regardless of time delay. In this case, the court discusses whether or not this is a violation of due process. Due process incorporates the concept that the government must treat individuals with basic fairness. The court stated that where the license suspension is delayed for an extraordinary length of time, the staleness of the predicate conviction tends to diminish the connection between the suspension and the statute's objectives of keeping unsafe drivers off the road, especially when there have been no traffic violations in the interim. The court further states that to the extent that a delayed notice of suspension is alleged to violate the driver's due process rights, there is no distinction in the law if the delay is caused by PennDOT or some other facet of the government. The next thing the court addresses is whether the court should take into consideration the interim driving record when determining if relief is due. The court states that they need not set forth a per se rule that any moving violation is fatal to a due process claim regardless of its nature, age, or severity, but note that the severity of the predicate offense and the severity and age of any further violations are relevant to the inquiry. This is because if it appears that the driver remains a danger to the public, it is difficult to argue that the suspension fails to satisfy the means-ends requirement, i.e. that due process is offended on the basis that there is little connection between a suspension of privileges and the legislative goal of protecting the public. The next prong is that the defendant must demonstrate that he or she suffered prejudice from the delay. This prejudice must be shown to be caused by the delay itself and not by the actual suspension. In this particular case, the court found that the defendant was entitled to relief. The delay was caused by the court failing to report the conviction. In the interim, the defendant had no further vehicle code violations, and he showed prejudice resulting from the delay, namely his change of circumstance due to the passage of time, including a worsening medical condition, divorce from his wife, and unemployment. In considering cases of this nature in the future, the takeaways are this. 1. If there is a delay caused by the court or PennDOT or some other facet of government, there is a possibility that the suspension can be overturned for a due process violation. To meet the burden, the driver must demonstrate that they are no longer a danger to society by showing they have no traffic violations in the interim and that there is prejudice caused by the delay. Now for this week's criminal cases. In Commonwealth versus Cochran, the defendant is contesting the imposition of restitution at a time other than his sentencing. In this case, the defendant entered a guilty plea and acknowledged that there was restitution, but was contesting the amount. He requested a separate hearing to determine the amount of restitution. Upon entering his plea, he was sentenced to a period of incarceration, and the restitution hearing was scheduled for a date approximately 2 months later. At the time of the restitution hearing, the defendant objected to the jurisdiction of the court, saying they could not order restitution because it was not done at the time of sentencing as is required by statute. However, the court concluded in this case that there is nothing in the law that requires that sentencing take place in a single day. Here, they found that the sentencing was bifurcated, with the incarceration portion occurring when he entered his plea and the restitution portion occurring later. There is nothing that prohibits this from occurring, and therefore it was proper for the court to order restitution at that later date. Commonwealth versus Montalvo is a PCRA case addressing ineffective assistance of counsel in a capital case. The defendant was convicted of first-degree murder and was ultimately sentenced to death. If you want more details on the facts of the case, the full case is linked in the notes. The defendant properly filed a direct appeal and later a PCRA petition. Following a hearing, in denial, an appeal to the Superior Court, a remand, and a new hearing, the PCRA court ultimately granted the defendant a new penalty phase as well as a new guilt phase trial based on counsel's ineffectiveness. The Commonwealth appealed. The basis for the ineffectiveness claim is that during jury instructions, the judge incorrectly stated, if the Commonwealth has not sustained its burden to that level, the burden of proving the defendant guilty beyond a reasonable doubt, then your verdict must be guilty. Clearly, the court should have said, your verdict must be not guilty, but defense counsel failed to object. The court finds that this failure meets the requirements for ineffective assistance of counsel claim because the claim has arguable merit and there was no reasonable basis for his failure to act. Further, the court finds that prejudice is established because the requirement of proof of guilt beyond a reasonable doubt is the bedrock of our criminal law, and the trial court's erroneous instruction was a basic and fundamental error that could not be corrected except by a new guilt phase trial. The Commonwealth argued that this was simply one inaccurate statement and that inaccuracy was overshadowed by proper and adequate pronouncements on the burden of proof before and after the inaccurate statement appears. However, the court noted that shortly after the first erroneous statement, the court again stated when discussing the elements of the offense, go down each one of those, don't jump down and keep it in chronological order. And I want to say simply, I don't want you to take this lightly and keep it organized for you. And as I said, if you find that the defendant was not involved in this, you should find him guilty on all those charges. Defense counsel corrected the judge and stated, not guilty, judge. And the judge responded by saying, not guilty. Now that was a Freudian slip. The Supreme Court found that this particularly troubling because a Freudian slip, also called parapraxis, is defined as a slip of the tongue that is motivated by and reveals some unconscious aspect of the mind. In characterizing her own erroneous instruction to the jury as a Freudian slip, the trial judge conveyed to the jury that she believed the defendant was guilty. The court agrees with the PCRA court in that the defendant is entitled to a new guilt phase trial. In the Commonwealth v. Summers case, the defendant appeals a resentencing after his sentence of life without the possibility of parole was overturned following the decisions in Miller and Montgomery. Those cases found that a sentence of life without parole for juvenile offenders was unconstitutional. The defendant was resentenced to 40 years to life and appealed his sentence. First, as to the discretionary aspects of his sentence, the court found that he properly summoned the jurisdiction of the court to address the discretionary aspects. The record indicates that the sentencing court considered the proper factors and came to a reasoned conclusion as to an appropriate sentence. The defendant is essentially arguing that the resentencing court prioritized the severity of the offense over the mitigating factors. His appeal on these grounds is nothing more than a request for the Superior Court to reweigh the sentencing factors differently, which the court cannot do. The court also found no evidence of bias or ill will in the record that would have resulted in an improperly excessive sentence. Finally, the defendant argued that a 40-year-to-life sentence is a de facto life without parole sentence. The court finds this argument without merit, as the law finds that if the person is afforded a meaningful opportunity to obtain release and potentially live several decades outside of prison if paroled at that time, then it is not a de facto life without parole sentence. Here, the defendant will be eligible for release at 57 years of age with the opportunity to live free for several decades. In Commonwealth v. Bennett, the defendant was pulled over for illegal window tint. Upon contact, the police discovered that he had a suspended license and also found an illegal firearm in the car. The defendant was arrested and booked into jail. Shortly thereafter, he sent his lawyer to enter a guilty plea to the summary offenses and pay the fines. After doing so, he filed a motion to dismiss the more serious misdemeanor and felony gun charges for failure to comply with the compulsory joinder rule. The court stated plainly, our precedent does not allow for this sort of chicanery. In order to succeed on a motion to dismiss for failure to comply with compulsory joinder, the defendant must establish 4 prongs. 1, the former prosecution resulted in an acquittal or a conviction. 2, the current prosecution must be based on the same criminal conduct or have arisen from the same criminal episode as the former prosecution. 3, the prosecutor must have been aware of the current charges before the commencement of the trial for the former charges. And 4, the current charges and the former charges must be within the jurisdiction of a single court. The Superior Court has held that in order for those protections to apply, there must be a former prosecution. The court further states that a lawyer showing up at the window to enter plea on your behalf and pay a fine is not a former prosecution, especially as the Commonwealth was not notified that the attorney would be appearing. It's plain from this case that you cannot avoid prosecution for more serious misdemeanor and felony charges by pleading guilty to and paying the fine on a summary offense. Commonwealth v. D. Williams is a PCRA case discussing whether or not the defendant is entitled to a hearing on newly discovered evidence exception. The defendant here was convicted of first-degree murder in 1987, and during his trial, a jailhouse snitch was a Commonwealth witness. In 2017, the defendant discovered that the witness had a record for crime and falsity and a history of cooperating with law enforcement. This evidence was not known to him at the time of trial. The PCRA court initially dismissed his PCRA petition as untimely because he did not file his petition within 60 days of the time the evidence could have been discovered. The court said the information would have been available to him as public record. While the defendant's case was pending on appeal, the case of Commonwealth v. Small was decided, which essentially eliminated the public records rule. As such, the court cannot say the defendant should have known about the records, and he is entitled to an evidentiary hearing under the newly discovered evidence exception. Commonwealth v. J. Williams is another appeal of a first-degree murder case. In this case, the defendant was convicted in 2018 and appealed on 2 evidentiary rulings. The admissibility of evidence is a matter for the discretion of the trial court, and a ruling thereon will be reversed on appeal only upon a showing that the trial court committed an abuse of discretion. An abuse of discretion may not be found merely because an appellate court might have reached a different conclusion, but requires a result of manifest unreasonableness, or partiality, prejudice, bias, or ill will, or such lack of support so as to be clearly erroneous. The first issue involved the court not allowing the defendant to present evidence to contradict a previous witness's testimony. The trial court stated that the evidence was irrelevant. The Superior Court disagreed and found that not allowing the evidence was an error, but no relief is due as the error was harmless. Harmless error exists where the record demonstrated either the error did not prejudice the defendant, or the prejudice was de minimis, or the erroneous evidence was merely cumulative of other untainted evidence which was substantially similar, or the properly admitted and uncontradicted evidence of guilt was so overwhelming that the prejudicial effect of the error was so magnificent by comparison that the error could not have contributed to the verdict. The court found that denial of the court to allow minimal impeachment evidence was a de minimis error, especially when compared to the overwhelming admitted evidence that supported a conviction. The second issue involved the admission of a letter that the defendant wrote to his cousin while in prison. The defendant claims that the potential for prejudice greatly outweighed the probative value. However, the court finds the evidence to be highly probative evidence with minimal prejudicial impact and therefore discerns no abuse of discretion. That's all the cases I have for you this week. Thank you once again for joining us. The link to this week's cases, as well as the cases not discussed today, can be found in the case notes. I hope everyone has a wonderful week.
Thank you for listening to the Pennsylvania Case Law Update While You Drive podcast. Be sure to subscribe to this podcast and our YouTube channel to make sure that you are always in the know when it comes to important changes in Pennsylvania case law. We want to thank this week's sponsor, the McShane Firm. The McShane Firm is a central Pennsylvania fixture when it comes to DUI and criminal defense. The attorneys and staff at the McShane Firm believe in good old-fashioned central Pennsylvania values like hard work and straight talking. Give them a call if you or a loved one ever needs help.